I trust that's contemplated to be done by Zoom.
Yes, Judge.
Hey, Mr. Barriger, that's the update.
Okay.
You're set for evidentiary hearing, which would normally be the function of this docket appearance anyways, to get an
Right from the start, Douglas Riney makes a bold legal move, waiving his preliminary hearing and fast-tracking himself toward trial. That's a high-stakes decision in a felony case. Is this confidence or quiet pressure behind the scenes? Stay tuned for every twist and subscribe now for more intense courtroom breakdowns.
All right, Douglas Riney?
Yes, sir.
Okay. This is State of Kansas versus Douglas Paul Riney. It's case number 2026, CR 65. Douglas Paul Riney appears from the detention facility Zoom location. James Watts is defense counsel. Amber Norris on behalf of the state. What announcement is made regarding preliminary hearing right in this case, Mr. Watts?
Your Honor, I've spoken with Mr. Riney. It's my understanding he would waive his preliminary hearing this afternoon.
All right. So, Riney, you heard what your attorney announced. I have some questions regarding you waiving your right to a preliminary hearing. Do you understand that a preliminary hearing is a proceeding to determine if there's probable cause that a felony crime has been committed and that you committed it?
Yes, sir.
You understand that if you waive preliminary hearing, the court will bind you over for trial at this point without any further determination of probable cause?
Yes.
And you understand that once you waive your right to a preliminary hearing, you cannot get that right back, though you may proceed to trial later.
Yes.
Now, did you have an opportunity to fully consult with your lawyer before making this decision?
Yes, sir. Yes, I have.
And do you now freely and voluntarily waive your right to a preliminary hearing in your case?
Yes.
Okay. Does the state of Kansas waive its right to a preliminary hearing in the Riley matter?
Yes, Your Honor.
Court finds that both parties have waived a right to a preliminary hearing in this case. Defendant is bound over for trial on all felony charges of the information, though at this point it appears there's a single count. We will proceed at this time to formal arraignment. Does your client desire the charging document to be read to him, Mr. Watts?
Your Honor, as Your Honor noted, this is a single count. I spoke about that would not be, we can waive formal reading of same. Enter a not guilty plea at this time. Ask the case be set for pretrial and jury trial settings. Your Honor, I might suggest a little bit of a short date, and I'll be getting an email to Amber this afternoon to see if we can get started resolving this case.
Okay. Mr. Watts, I can offer, I know that there's a case on this docket that very well may go ahead of you, but I can offer the trial date of April 28th with a pretrial the week before.
And
You already have two there, Mr. Watts.
Your Honor, I would not be available for the pre-trial. Someone else could probably cover that. But I'm not back in the office actually probably until the 28th. So it's not ideal if it was to be for trial. So I would ask to avoid at least that trial date. But if you just want to set a pre-trial dispo on the 24th, that's fine.
Judge, I can do the 28th, and I believe this is going to be resolved by plea. I hate to say a guarantee, but it's highly likely.
I can offer a setting at 1:15 p.m. on Friday, April the 24th.
Yes, sir.
I think I'm scheduled to be in Greenwood County that morning, but if 1:15 will work, we can go ahead and set it there.
Yes, sir, I can do that.
All right. Court will set the Riney case for status and possible plea. 1:15 p.m. Friday, April the 24th. I am not going to place this case on the jury trial docket at this time, but Mr. Riney, I need to address you personally about this. I've given you a very fast court date as far as felony cases are, as far as scheduling is concerned, just over a month. We could normally be looking at a 4 to 5 month delay. But
Yes,
I'm going to
sir.
go ahead and set your case in a month, but you will not be on the April jury trial docket. Is that all right with you?
Yes, sir.
Now you've got plenty of speedy trial time left, and I can get a speedy trial scheduled after that if you don't get it worked out through your attorney. But I want to make sure you understand that you're not going to be on the April trial docket the week after. We're just setting you kind of on the pre-trial docket the week before, and that's okay with you?
Yes, that is fine.
All right. The court then will set this 1:15 Friday, April 24th for possible plea. We will schedule a jury trial at that time if necessary. Okay.
Thank you.
All right. With that addressed, is there anything else, Mr. Watts, that we need to address on Mr. Riney?
No, Your Honor, thank you.
Anything further from the state at this time, Ms. Norris?
No, Your Honor, thank you.
You have any questions about what we've done here today, Mr. Riney?
No, sir.
Very good. Then if there's nothing further, the Riney case will be in recess at this time.
Thank you.
Around this point, the court smoothly transitions. But look closely. This scheduling discussion reveals strategy. A likely plea is hinted, meaning both sides may already be negotiating behind closed doors. That's how many cases end quietly. Do you think this will settle or explode later in court? Let me know your thoughts.
Audio input.
All right. I've got a Spillman file here, Mr. Watts. And I will call that case State of Kansas versus Hunter Spillman. It's case number 2024 CR 392. Amber Norris appearing for the state. James Watts as defense counsel of record. Docket notes indicate that this matter came before Judge Hart on February the 13th. Defendant appeared by Zoom. It was set on this docket, March 16, 2:30 p.m. by Zoom. Okay, who do I have? Is that Mr. Spillman at the detention facility?
No, Your Honor, this is Eldon Barriger.
Okay. All
His-
right.
His cases were moved at his attorney's request.
I'm surprised he doesn't know that his cases were moved. Mr. Barriger, I regret that. But it is also the court's recollection, though you were originally on this docket, you were taken off by your attorney, Mr. Ambrose. He had a scheduling conflict, which caused us to have to reschedule. Mandy, can you assist me in letting Mr. Barriger know where he got reset to?
Yes, Judge. It is reset for an evidentiary hearing April 14th at 3:30 p.m. by Zoom.
And
Is
Judge,
it
that's
3:30, Mandy, rather than 3?
Correct.
Okay, I have it. Okay,
That's when he could appear. I'm sorry.
okay. And I trust that's contemplated to be done by Zoom.
Yes, Judge.
Hey, Mr. Barriger, that's the update.
Okay.
You're set for evidentiary hearing, which would normally be the function of this docket appearance anyways, to get an evidentiary hearing set if you want one. Your attorney does want one. Apparently you do too. And that's now set 3:30 p.m. Tuesday, April the 14th. A very, very prompt setting.
All right. Thank you.
Okay. Then I think I'll conclude our business on him today.
And that's all for the jail, Your Honor.
Yes, and thank you for your assistance today. All right. State of Kansas versus Hunter Spillman, 24 CR 392 remains. I had earlier read the notes from Judge Hart's first appearance. Mr. Watts, any explanation as to why your client's not on the meeting?
I do not. Can you still hear me, Your Honor?
I can. You're a little distant, but I can
Well,
still hear you.
I see my video's frozen, and it's telling me I've crashed, but I have just this last one. I'll try to hang in before we try to fix it.
Okay.
I've not heard from Mr. Spillman. I don't have a response on the phone number I have. It comes back as he's not available.
I see he also failed to appear for his very first setting on this case back in September. I'm a little concerned here. Ms. Norris, do you have any explanation as to why Mr. Spillman wouldn't be able to attend?
I do not, Your Honor. He is out on bond, and he's not in custody in our jail, so I don't have any information about Mr. Spillman.
Okay, thank you. I
And
was just
trying to
looking to see if
determine-
I had information as to who his bondsman is. Nevertheless, at this time, due to his non-appearance on this felony case, and knowing that the date and time on the docket sheet corresponds with this court's understanding is when he was ordered to appear, court will order bond forfeiture, a bench warrant for Hunter Spillman's arrest, with him to be held on a no bond hold pending further proceedings in the case. I also note that this was a case originally filed in 2024, so we need to get this case moving through the system, and obviously we need the defendant's appearance to do that. So bond forfeiture, bench warrant, no bond hold. Ms. Norris, anything further that you believe needs to be addressed on this docket?
No, Your Honor. Thank you.
Thank you. Mr. Watts, anything further?
No, sir, thank you.
Thank you for bearing with us through this hearing, despite your loss of video. It'll be good to see you moving in the future.
Yes, sir.
At this time, the preliminary hearing docket is concluded and the meeting may be ended.
And just like that, the tone shifts completely. Spillman's absence triggers a bench warrant and no bond hold. That's a massive legal setback. One missed appearance can undo everything. This ending leaves serious consequences hanging in the air. Like, comment, and subscribe for more real courtroom drama and powerful legal breakdowns.